Chicago prenuptial agreement. Lawyers planning to marry and want clarity about money before you sign the marriage license. A prenuptial agreement can protect assets, clarify expectations, and provide peace of mind under Illinois law. In Illinois, a prenuptial agreement is a written contract made before marriage that defines financial rights if the spouses divorce or if one spouse dies. These agreements are governed statewide by the Illinois Uniform Premarital Agreement Act, 750 ILCS 10/1 et seq. Under that statute, the agreement must be in writing and signed by both parties. Oral agreements are not enforceable, no matter how detailed the discussions were. The agreement becomes effective only when the couple marries, and it has no legal effect if the marriage never occurs. Illinois law allows broad freedom in prenuptial agreements, but important limits apply. A prenup cannot contain provisions that violate public policy or impose criminal penalties. Most importantly, a prenuptial agreement cannot adversely affect a child's right to support. That means you cannot predetermine child support amounts in a prenup, because courts decide support based on guidelines and the child's needs at the time of divorce. You also cannot include binding terms about child custody or parenting time, because Illinois courts decide those issues based on the child's best interests at the time of the case. Within those limits, Illinois prenuptial agreements can address a wide range of financial matters. Couples can specify which assets remain non-marital property and which become marital property subject to division. That can be especially important for real estate, investments, and business interests brought into the marriage. A prenup can also address how income and earnings during the marriage will be treated, even though Illinois often classifies income earned during marriage as marital property by default. Spousal maintenance can be addressed by agreeing on a specific amount, waiving it, or using a formula for calculating it. Illinois courts can refuse to enforce or can limit a maintenance provision if enforcing it would cause undue hardship under circumstances not reasonably foreseeable when the agreement was signed. Prenuptial agreements can also be used to protect business interests, keep inheritances separate, and address what happens if a spouse dies during the marriage. If you own significant assets before marriage, a prenup can help prevent commingling that could otherwise put those assets at risk in a divorce. If you anticipate an inheritance, a prenup can provide explicit protection even though inheritances are generally non-marital property, because handling and commingling can change outcomes. If you are entering a second or third marriage, a prenup can support estate planning goals and help protect children from prior relationships. If there is a significant income disparity, a prenuptial agreement can set expectations about maintenance and financial responsibilities up front. If one partner has substantial debts, a prenup can help prevent the other spouse from becoming responsible for obligations incurred before the marriage. To be enforceable in Illinois, courts generally look for voluntary signing and terms that are not unconscionable, particularly where there was fair financial disclosure or a knowing written waiver and adequate knowledge of the other party's finances. Starting early matters because agreements signed shortly before the wedding may be scrutinized for duress or coercion. As a practical matter, beginning 3 to 6 months before the wedding can allow time for disclosure, negotiation, and independent review. Complete financial disclosure should cover assets, debts, and income from all sources, and it is typically documented in writing and attached to the prenup. Independent legal counsel for each party is strongly recommended, because separate representation increases the likelihood a court will enforce the agreement. A typical process begins with an initial consultation, followed by gathering and exchanging financial disclosures. After disclosure, one side's attorney drafts the agreement and the other side's independent attorney reviews it and negotiates revisions. Once both parties agree on final terms, signing should occur well before the wedding, and the agreement becomes effective on the date of marriage. If you are already married, a premarital agreement can be amended or revoked only by a written agreement signed by both spouses, and this is often referred to as a postnuptial agreement. Courts apply stricter scrutiny to postnuptial agreements, which makes independent counsel and full disclosure even more important. A prenuptial agreement can also be challenged in divorce proceedings on grounds like duress, inadequate disclosure, or unconscionability, which is why time, transparency, and independent review matter. At Caesar & Bender, LLP, prenuptial agreement attorneys Molly E. Caesar and Michael Ian Bender guide clients through drafting, review, and signing with nearly 50 years of combined experience. If you want to work with a lawyer on a prenuptial agreement, the goal is a clear written contract that fits your finances and follows Illinois requirements. If you need an attorney to review what can and cannot be included, understanding the Illinois Uniform Premarital Agreement Act is the starting point. This law firm also helps clients understand how Cook County family law practice approaches enforceability when agreements follow proper procedures. If you are looking for a lawyer to start the conversation early and document full disclosures, that preparation can reduce disputes later. For help, call Caesar & Bender, LLP at 312-236-1500 and visit 150 North Michigan Avenue No. 2130, Chicago, Illinois, 60601, United States.